All right, this is another in a series of what to do when you appear in court and how to act and how to argue. And in this case, this is an important one that I receive requests about all the time, which is how do I argue a summary motion hearing? Excuse me, a bit of a cold. The first thing you have to know is that this is no different than my analysis for you that you should conduct. What is the linchpin of their argument? So it's what's the linchpin of their lawsuit? Knock that out, you knock out the lawsuit. Well, that carries on because when you have a summary motion filed against you, or a motion for summary disposition, or a motion for judgment, you have the same lawsuit against you, and they are saying, we've made a true finding of the law here. Court, you don't need to go into the facts. We've met our burden of proof, which is what they're saying with their complaint. So you can transfer that linchpin analysis to their motion for summary disposition. So we're going to look at that today for you. And I am going to argue a motion that I'm actually going to argue tomorrow. So you're going to hear my arguments against what's coming my way tomorrow. How can I do that the day before? Because I know their case intimately as well as I know my own. That's your first lesson. Number two, obviously know your own case and why you should prevail. You are still using the linchpin analysis. So you would take their summary motion as you would the lawsuit, tear it apart, and you'll see a prevailing theme of two things. At least that's what I do, and you probably will too. Here's why we should win. Here's how we met our burden of proof. That's the same as winning. And then they attack you or your defense. Don't take it personally, although it is personal for me a lot of the times. But advocacy and arguments are two different things in that I often see the other side make these flowery statements about what a jerk I am, or this is another attorney trying to get his client out of debt that they owe. That's fair, that's fine, it's not true, but I like that because it tells me they got nothing if they have to attack me, right? So you may see that, don't take it personally for the purposes of arguing your good case. So you break down their motion into simple parts. Why? Because you will eventually see the linchpin that doesn't make sense. If it doesn't make sense to you, it shouldn't make sense to the court. And that is your argument. I say the first time you read it and something bothers you, key on that. And then when you read it again and get to know it better, meaning their argument, key on that and ask yourselves, how are they supporting the linchpin? The same thing you ask when you look at their complaint. So again, it's very important that you know your arguments and you know their arguments. And I know what's coming my way tomorrow, okay? However, I will often hear things that don't appear in their paperwork. That's sort of not the way it's supposed to go, but things slip by. So you must, in your head, do a sort of triage, meaning you hear a couple of lies, things that aren't true, blah, blah, blah. Decide in your head how important it is to address every single thing they bring up, and does it take away the attention and the time that you need to make your stronger argument. So in other words, is there any value in refuting some minor points or lies that they make when it causes your strong arguments to not get the time and play that they need? And I would argue, focus on you. Unless, I say triage. If it's just a broken leg, so what? The guy's got a wound close to his heart. Now that needs to be addressed. So you have to decide quickly, is it hurting my argument to address minor stuff? Focus on you. You be you, okay? Your arguments are really just a presentation of your side of things of this counter affidavit that attacked their lawsuit originally. And I always counsel you, do that counter affidavit, do the work, and it will follow you and do all the work for you. And you'll notice the counter affidavit has all the arguments already made against a motion you haven't even seen yet. And then when they write it, you go, huh? And they'll try to address your arguments, and they'll always do it badly. And there's a reason we've talked about as far as securitization. So in the argument I'm going to make tomorrow, I'm going to try to do it now for you. I've given you some tips. You have to follow these points real quickly, then I'll go into my argument. Break the motion to simple parts. Is it a chain of title that they are claiming gives them the right to sue you? It always is. So knock out its weakest link. What is the linchpin? That's it right there. Knock out the weakest link. Find the linchpins in any of their arguments, and if their own documents counter those arguments, which generally they do, find a way to bring that up to the court. Knock those out and you win the motion. So I am now going to present you the way I presented it to the court. Okay? May it please the court. Your Honor, I just want the court to do one thing as it hears my client's side of this. And there's really only one side once you hear what I have to propose. I would like you, court, to ask yourself the following. How did Upstart Pass-Through Trust Series 2021-S28 obtain the debt, and from whom? As you may recall, we initially, in this case, prior to answering the lawsuit, I filed a motion for more definite statement and a motion to dismiss on that very question, Your Honor. And the question was, where's the proof that this secured trust, I'll say it again, Upstart Pass-Through Trust Series 2021-ST8, obtained the debt to give it to Velocity, as the other side alleges in its bill of sale? And the court said, and I quote, that the plaintiff will provide documents showing a complete chain of title within 30 days of the matter goes to trial. Your Honor, we do not have the very thing, the basis of the motion and the basis of my counter affidavit and the basis of the defense. We have nothing showing how Upstart Pass-Through Trust Series 2021-ST8 received this debt. A side note, housekeeping, don't fall into the trap of the other side using the word Upstart as though it applies to Upstart Pass-Through Trust. Those are two different entities. One is an entity out of Utah, Upstart Network. The other is something founded and formed in Delaware. In a nutshell, I will read the other side's motion to show how the court ruled on my last motion. The court did not grant defendant's motion, but ordered Velocity to produce all the documents intended on relying upon court at trial, showing the chain of title from the original creditor to the assignee Velocity. As you can see up on the screen, plaintiff produced and filed the documents via M-File, including business records affidavit from the original creditor, Upstart Network, Inc. That is so important right there, because the original creditor in this case, Your Honor, is FinWise Bank. Why would the other side make a mistake or change or misrepresent when the original creditor right there is FinWise Bank? You've got them right there, Your Honor, because they know who the original creditor is. It's in their documents that they supplied the court. It's FinWise Bank. Yet, in their very motion to you, just recently filed, they have a false statement, similar to their lawsuit. But I will get into that later. They then say they have a transfer agreement showing transfer of the loan from the funding source, FinWise Bank, to Upstart Network, Inc. It may well be that FinWise Bank is a funding source, but they first and foremost are the original creditor. That's the company that Mr. Jimenez went to obtain a loan. They also talk about a bill of sale and the sale of the loan from Upstart Network, Inc. to Velocity Investments. All right, so there's your next falsehood, Your Honor. The bill of sale is from Upstart Pass-Through Trust Series 2021-ST8, and it claims to be selling something to Velocity Investments. Those are two different entities. The summary motion at its core, besides being hopefully an article of truth, is to show you, Your Honor, that this passed from the original creditor to Velocity for it to have standing to sue my client. And they can't even tell you who the original creditor is to claim to own it. And if that's not a falsehood, if it's a mistake, if you owned it, you wouldn't make that mistake. Again, I want the court to ask, in the bill of sale, how did Upstart Pass-Through Trust Series 2021-ST8 obtain the bank from FinWise? FinWise, the original creditor. You have nothing in front of you that shows that, Your Honor. I'll look at the complaint very quickly, and that produces a paragraph 2, which says, defendant became indebted to the plaintiff upon receipt of the funds. That's a falsehood too, because defendant became indebted to FinWise Bank. If you don't believe me, just look at their paragraph 1, where it says, defendants requested a loan from FinWise Bank. Plaintiff is claiming to be the current owner and was assigned all the rights, title, and interest to defendants, and they call it a FinWise loan. They don't call it an Upstart loan. So getting back to what they state in their own motion, they're not telling you the truth. The linchpin of the lawsuit then is that they failed to produce anything that shows the truth of their complaint. They're claiming something that is not true. Their argument is, hey, we got the debt, it was assigned to us, therefore we're in the shoes of the original creditor. The original creditor, they claim, is an entity that isn't the original creditor. So that would not be a true statement. If you look at the approval disclosure form, I'll put it up on the screen for y'all. That says creditor, FinWise Bank. Any questions? So clearly when they say Upstart Network is the creditor, that's a false statement. So until you find out, receive, just give us something that shows how Upstart Pass-Through Trust Series 2021 ST8 received this debt. There is no perfected chain of title, and they can't sit in the shoes of the original creditor who they falsely claimed was somebody else. So defendants, affidavit, answer, affirmative defenses, the counter affidavit, everything we've shown the court shows that FinWise Bank is the original creditor, and this weird Upstart Pass-Through Trust Series 2021, while claiming to be the owner of something, has received nothing from FinWise Bank. Indeed, it says right in its own bill of sale, Upstart Pass-Through Trust Series 2021 ST8 as the initial seller and on behalf of the additional sellers. It is not the initial seller. It can't be the initial seller because FinWise Bank is the original creditor. FinWise would have to give that to Upstart Pass-Through Trust for it to be, even then it wouldn't be the initial seller. It maybe be the current seller, but there's no ownership presented to you by Upstart to pass this to Velocity as the bill of sale states. It's a FinWise Bank debt, and without anything moving to this trust, they can't sell anything to Velocity. So that's the linchpin of my argument. There's no record of anything being granted or transferred to Upstart Pass-Through Trust for that bill of sale to be relevant or even true. They have supplied what's called a transfer of loan sale, and in that case, the transferor 6 days after this bill of sale is sending something to Upstart Network. Well, obviously right then and there, their own documentation is telling you that Upstart Network isn't the original creditor they stated in their motion. So I don't know why they change things so much, but that's not a sound argument to make when you're asking a conclusion of a case. Get your facts straight. And that was 6 days after something was supposedly sold to Velocity. Indeed, the court should also ask itself, how did Velocity get this from Upstart Network Inc. if Upstart Network Inc. truly did receive the loan of my client? So you might see, Your Honor, that in paragraph 4, this is funny the way they write this, to the best of transferor's knowledge, on or about the respective closing date set forth in Exhibit A. There's no Exhibit A. Transferee transferred or otherwise conveyed each loan to the party identified in Exhibit A. You will not see an Exhibit A attached to this motion. They may come up with something now and go, okay, this is Exhibit A, but you'd think that they would do that. So where is the Exhibit A is one linchpin, and no loan of my client is part of any missing Exhibit A. So they do make somewhat of an effort. I'll put up what they say for the viewers here. Shazam. And they claim that my client's loan was funded by FinWise Bank and serviced, as you know, and serviced by Upstart Network Inc. Your Honor, servicing there's no ownership in a servicing agreement. FinWise is the original creditor. Although their own document number 1 is now claiming that FinWise is the original creditor, as the loan agreement does, different from the beginning of their summary motion. I mean, this is enough for me to show that there's a dispute just by their words and actions, but I'll quickly go on. March 24th, they say FinWise Bank transferred the loan, transferred or otherwise conveyed each loan to the party identified in Exhibit A, and they go effectively into some date argument, which doesn't make a whole lot of sense. I know where they're going, but they still have not answered the elephant, a rather large elephant in the room, which is, how did this Upstart pass-through trust get this debt? And you still do not have that. So they tried to support that further with a affidavit born out of litigation rather than some independent, effective, chronological look at how all these companies obtained this debt to sue my client. And if you would be careful to look at I believe it's number 3 of their affidavit. It says, Velocity Investments acquired such loans and interest from Upstart Pass-Through Trust Series, blah, 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 and has serviced the loans. They haven't. Well, Upstart has serviced them, but there's no proof as to how Upstart Pass-Through Trust Series 2021 ST8 has received to give anything Velocity 6 days prior to the original creditor, FinWise, giving it to Upstart, the original servicer. As you know, Your Honor, we'd previously filed a motion for more definite statement. The court ruled that they have to provide these documents or it goes to trial. Clearly, there's no evidence here of how this weird entity, Upstart Pass-Through Trust Series 2021 ST8, received the debt to give to Velocity. That's the linchpin of both their lawsuit and their motion. By the way, their lawsuit, no mention of Upstart Pass-Through Trust and no mention of Upstart Network Inc. receiving anything from the original creditor. They just sort of pass over that. I would argue then, Your Honor, there is no reason for this not to go to trial. This really just goes back to the original motion that plaintiff filed. They've stated how we haven't properly answered timely. Your court's ruling did not acknowledge any of that, just that they first had to provide the proper documents, and then they filed the motion to dismiss. Interesting, Your Honor, in their attempt to provide the documents and in their motion, they say there's 307 pages that prove their case. You've yet to see that. Does the assignment to this Upstart, I'll try to remember, Upstart Pass-Through Trust Series 2021-S28, exist within that 307 pages? Can we just see that? They have failed to provide that to you. So without that critical point of the chain of title, they are not the assignees of my client's debt. They therefore do not stand in the shoes of the original creditor, which they can't even tell you. They've given you two choices. There's only one original creditor. The next kind of creditor is called the current creditor. We don't know who that is. Because they've thrown in this upstart pass-through trust series 2021, they've kind of killed their own case. And that's generally what's happened here. Their own documents have killed their case. I've more than met my client's ability to show you that there is a very genuine material issue here with the ownership here. My client there's no right to sue my client. And I would ask that this court deny their motion and send this immediately to trial as it ordered when I first filed my motion for more definite statement. Thank you very much, Your Honor. If there's anything else, I'd be glad to entertain any questions. Thank you. And so, hey, that's what we're doing. I hope that was helpful. I'm not perfect, but that's pretty much how I argue an assignment case, whether it's, in this case, against Velocity or against PRA or LVNV funding or Midland Credit, Crown Asset Management. They all come in the same way. They present their chain of title that they were careless on at the very beginning of their lawsuit, because they know 9 out of 10 cases are probably going to go and get defaulted anyway. That's the national statistics. So they're careless, and then you go into that area and point out how wrong they are. Why they don't present the real things, there's two reasons. Number one is because when these debts are created, the originator, which is the original creditor, securitizes them and sells them off to a bunch of tranches. In this case, that's what that company was. It's just one of many transferees of the debt that they securitized. That's a problem for debt buyers. They twist themselves into pretzels. That's why I call it pretzel litigation, because they can't prove that their client owns the debt if you look at the chain. They bought it from chain of title. They bought it from somebody. So a common thing you're going to hear, I'm glad I'm talking too much because now I can remember the thing I wanted to tell you. Don't be fooled by in this case, this motion, I'll add it to the website. Don't be fooled by their emphasis. Well, Mr. Debtor made payments. He allowed us to take the money out of the debt. First of all, they didn't. He didn't. They never took a cent from my client. He paid the original creditor. But before they can claim they own the debt as the current creditors, they must show ownership of the debt. So any payment he made is irrelevant. So you're going to hear the judge get suckered into that 9 times out of 10 and go, but Mr. Smith, isn't this your debt? Your Honor, that has nothing to do with whether it's their debt. The debt collector here does not own the debt. And it can't claim that I owe them because I paid somebody else. It can only claim it owns the debt with the right chain of title, which in this case does not exist. Otherwise, people could just go around claiming, yep, they got it to me and he made payments, therefore they owe me. It's a silly argument. But you're going to face that. And that's a lazy judge, I'll be honest with you. A judge going, well, you made payments on it. It's your debt. What are you getting into semantics for? I just filed an appeal with a judge that said that very thing. And I said to the court, and what I did is I took his transcript where he actually said, this is just semantics, the law. And I put that at the top of my claim, my brief, saying, this is how that judge ruled. Here's all the law I presented. Here are all the facts. Judges said, just semantics. When our laws are just semantics, that's indicative of a lazy, don't want to do my job jurist. And we pay them quite a good living to trust that they will give us all a fair shake. Look at their side, look at my side. In that case, for example, and I'm making a big example here. You will see judges that will try to win the case for the other side. It will feel like that. If they've ignored the law and the facts and the chain of title, then they have lost their neutrality. You can remain neutral by taking an honest look, I'm talking to judges, at this argument and that argument. I can hear it when you've argued the details, you've read the details, and I don't ever like to lose, but I understand your frustration when it feels like the judge is against you because he didn't listen to you. It's probably true, but he's not against you personally. He's against the work involved in doing his job, and that's my opinion, okay? Because I've been 30 years of seeing that. And you also see good judges that deliberate, and I don't want to ever lose, but if I lose to a judge where I can see he did the work, he's done a good job for me. Maybe I missed something. And I'm okay with that. I don't ever want to lose, but a well thought out and pled decision is all I ask for. So don't let any judge get away with saying, but you made payments on this. Have your argument. Your Honor, that's irrelevant as to their ownership, and they've not met their burden of proof, proving they have the right to pursue me. So we don't get to whether I owe them or how much I paid until they prove they own it. I know I've kept on and on, but this will be useful to you as a means to argue your case. I hope it is. And this is the argument I'm going to make tomorrow. I thank you, Brian Park.